Everybody to settle down so we can get started, and we're a little behind schedule, so we'll try to catch up very quickly. Okay. All right, since my name happened to wind up in the middle, I guess I'll be the informal moderator of our session this afternoon. And in the interest of time, we'll self-introduce so that we don't take too much time introducing people, and we'll conserve that time for our presentations, which I will start into immediately. My name is James Duffy. I'm a New York lawyer, and I spend a lot of my time these days working on a number of matters, including rule of law issues and UNCITRAL issues, and you're going to hear a lot of that in the presentation that I'm going to give in just a moment. And I should apologize, I'm normally a little more formal than this. Unfortunately, I lost my luggage. It's somewhere between here and Paris. Air France just sent me an email message telling me they are diligently trying to find it, which does not leave me feeling very comfortable that they have any idea where it is at the moment. But I hope it'll catch up with me at some point. Now, I'll try an attempt at American humor. When I first read this title, it reminded me of a joke which starts out, "What's wrong with the world and how do we fix it?" And that's a pretty tall order. And I think legal challenges for rapid economic growth probably comes very close. I am going to confine my remarks to the rule of law. And I think you will see from some of the presentations we've heard earlier today, particularly from Mr. Justice Singh and others, there are many rule of law issues here. So what you might want to think about as I go through some of these things is that this tends to give a context to many of the things we've discussed here, puts it into a different type of focus. Now, many of you may have a very different impression of the rule of law because very often it's thought about in the context of personal rights, civil rights, and so on. However, the rule of law also has a very significant implication in commercial matters. And that's what I'm going to talk about right now. What is the rule of law in commercial matters and why is it important? And I'm going to, I do have a paper, I think it's up there. I'm going to try to go through it a little faster. I'm going to skip over a couple of things. I think the paper is going to be available if it isn't already on the website. So if you want to see it in more detail, look at it in the website, and I will just go over some of the highlights in the interest of time. Now, one of the essential ingredients of the rule of law in the commercial context is a good contract law. And that is in large part because in order to have an effective economy, you need to have a way of creating relationships. You need to be able to compel compliance with those relationships if they don't work. And you need to have some way of imposing the remedies that come about from the contract if they don't work. And as you've heard in many of the presentations here today, despite the best intentions of people, contracts don't always work out. And normally, it's been my experience, what I try to do is I try to encourage my clients to find their own solutions. because I think the solutions that they fix, the business solutions that the business people involved craft to resolve the problem are probably going to be far better than a solution that some judge or an arbitrator who may or may not have any significant appreciation for the industry, the business, the problem at hand. But that doesn't always work. And I guess one other thing that I should mention in an effective contract law is that the contract law should require the parties to perform the contract in good faith. I think that's a very important issue. Now, not all legal systems do that. Most U.S. legal systems do. I don't believe the UK has a requirement for good faith performance. Certain jurisdictions in Europe do. But certainly when you're talking about New York law, there is a very, very strong obligation to perform the contract in good faith. And I think that can become very important in certain matters. Now, the importance of a good application of the rule of law is underscored considerably by the World Bank. And Arun tells me that he was just at a World Bank meeting here and in Uncentral, and a number of other studies that have been made. So the first thing we need to focus on is that we do establish the rule of law, because without the rule of law, it's going to become very, very difficult to have an effective economic system. And again, I mentioned also UNIDROIT in the paper. So you might just take a look at that section, and I'll pass over that at this point. Now, I also think that we should mention, but I'm not going to spend a lot of time talking about it, that corruption has a very, very corrosive effect on the rule of law. And corruption in commercial transactions has an equally corrosive effect. In part, it's going to deny the company of the honest services of its employees, or the government of the honest services of its agents. People are going to buy products that are inferior or not suitable for the purpose at hand, or pay too much for those products, depending on where the bribe, which side the corruption is coming from. So I'm just mentioning that, and I'm not going to go further with that. Another thing that we need to focus on, which has been spoken about at the conference here, is that when you have an appropriate system that's consistent with the rule of law, you have a way of approaching solutions to remedies where the parties themselves are incapable of finding a solution. And that means that you have a court system where you have well-informed, honest judges who can reach resolutions within a reasonable time, and who can reach those decisions in a system which does not charge unacceptable or excessive costs in reaching those decisions. And you've heard, I think, a number of people talk about how expensive litigation can become. Now, that is a particularly serious problem when you're talking about micro, small, and medium-sized business enterprises. Larger business enterprises are perhaps better able to absorb the cost of litigation, but micro and small businesses find it very, very difficult to do that. Now, happily, many legal systems do, in fact, have small claims procedures which are abbreviated procedures that operate more quickly and theoretically are less costly. And so that's something that you need to focus on in terms of what sorts of legal changes are necessary to have an effective rule of law type of legal system, and that is small claims procedures. Now, these have to be consistent with due process. Due process automatically requires certain notice periods, certain delays in between various steps so that the parties can effectively assert their rights and pursue them. But in small claims procedures, you can abbreviate that. In very large transactional situations, you probably cannot. But large transactional situations tend to imply large companies, and as we said, they are better able to deal with the costs and the delays of litigation. The third prong of the legal system is the effect of the remedy. It does very little good if you have a remedy that you can't enforce. And this becomes a very, very difficult problem when you are talking about small businesses, micro-sized entities, who can, by using the internet, do business in jurisdictions other than their own. And that raises two issues. The first one is the contract issue. Where was the contract made? And you will have, I make reference to the Vienna Convention, the UN Convention on International Contracts for the Sale of Goods, commonly called the Vienna Convention. That's one way of dealing with a problem like that, and I will refer you to the paper for additional information. But the problem is that you get a remedy, a judgment, an order for specific performance, or some other relief from a court, and now you are in India, and the party against whom that order or judgment is issued is in Sweden, New York, wherever. What do you do? How do you enforce that? And there are very few at the moment treaties that enable you to do that when you're dealing with a court-issued judgment. However, when you have an arbitral award, there is a convention commonly called the New York Convention, which provides for a relatively easy mechanism for enforcing an arbitral award. Unfortunately, for small businesses, micro, small, and medium-sized entities, arbitration is often becoming so expensive that if there is a small claims procedure, that most of them will elect to use that small claims procedure. Now, in New York and many of the U.S. states, the small claims procedure actually pushes you into arbitration for that very reason, that the arbitral award would fit under the New York Convention and would be enforceable in that context. But if you choose an award, rather if you choose the court procedure, then you have to enforce a judgment in a foreign country, and there are, as I said, very few effective treaties. Within the European Union, there are treaties that allow you to do that, but someone in the United States would not be able to avail themselves of those treaties. Someone in India would not be able to avail themselves of those treaties. And let's see. I think we've spoken about most of the points that I wanted to raise. I should also talk briefly about another aspect of this picture, and that is that if you are going to have enforceable contracts, you're also going to have some mechanism in your legal system that will allow the parties to go through some sort of bankruptcy or reorganization procedure. And so that if they are incapable of dealing with the consequences of a contract enforcement effort, they can either declare bankruptcy in an orderly way or reorganize in an orderly way. The preference in many parts of the world is for reorganization. If you have a business that could otherwise continue to employ people, that's generally thought to be more desirable than just liquidating the business and putting everybody out of work. And let me see what else. And I think I will sum up by saying that the evidence is somewhat anecdotal in many cases, but an awful lot of people who have looked at this question very, very closely, and I've named some of them, the World Bank, Vincitral, among others, have concluded that those countries that embrace the rule of law in all of its aspects, not just its civil rights aspects, but in its commercial aspects, typically enjoy greater prosperity, greater freedoms, greater liberty, and also greater economic success. And we are lawyers, and you've heard several speakers indicate that lawyers play a significant role in nurturing the rule of law. And I would certainly encourage all of us as lawyers to take a very, very hard look at what the rule of law is in all of its contexts. And I think it was Mr. Justice Singh this morning said the rule of law is not rule by laws or the rule by laws. It means something quite different. You know, it may or may not be something that's in your consciousness here in India, but people in New York, in the U.S. and Europe, remember, particularly older